Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked before about governmental immunity, the concept that you cannot sue a government official for acts he or she takes while in office. And there's problems there, of course, because bad actors can do very, very bad things and be protected by governmental immunity. Well, several people sent this story to me, and it already had crossed my desk. I'd spotted it myself and was making a mental note to do a story on it. Several people sent it to me, including John. And here's the thing. This is an extreme example of what can happen because knowing they have immunity, sometimes people will do even crazier things knowing that they can get away with it. And that's just how human behavior is. So this story is from reason.com, but I've seen it reported elsewhere. A Michigan police task force is playing jurisdiction games to avoid compensating an innocent man cops put in the hospital. Scott Shackford wrote the story. James King was walking in Grand Rapids, Michigan back in 2014, and he's now still trying to get these officers who did some stuff to him to be held responsible for what they did, and this case might wind up in front of the U.S. Supreme Court. So here's what happened. A detective with the Grand Rapids Police Department and a special agent with the FBI approached King, mistaking him for a man wanted for breaking into the house of a former employer and stealing. According to King, they did not identify themselves and started asking him questions. They then pinned him against an SUV and took his wallet. King thought he was being mugged, and he tried to run. The officers then attacked King and beat him unconscious. Now, again, this is a police officer from Grand Rapids Police and an FBI agent, and that's extremely important. One is a federal agent and one is a local state person, okay? So bystanders who watched what was happening thought that King was being attacked. They didn't know these people were police because they were in plain clothes. Someone called the police and other people filmed what happened. When the police officers arrived and realized that it was two cops attacking this guy, they ordered bystanders to delete the video they had taken of the beating. Some of them complied, but not everyone. Rather than acknowledge that they mistook King for someone else, police and prosecutors instead charged him with assaulting the police officers and resisting arrest. They tried to get him to accept a plea deal, but he refused. They forced a trial, and of course, he was facing years in prison if convicted. Now, here's the thing. The jury acquitted him. So that's not resisting arrest. That's not assaulting a police. You're not resisting arrest if you don't know they're cops. And they never said we're police officers. So this whole legal battle bankrupted him. So King filed a lawsuit in 2016 accusing the two officers, one of whom was a Grand Rapids Police Department officer, and one was an FBI special agent. And he said that they violated his constitutional rights. Makes sense, right? After filing the lawsuit, King and his legal team hit a jurisdictional problem. The two officers said they were part of a multi-agency task force, and neither the state nor the federal government are willing to say that the officers were operating under their jurisdiction. So even though the investigation and the crime wasn't a federal crime, the officers claim federal immunity in Michigan courts. King's legal team is now petitioning the Supreme Court to stop the police and the Department of Justice from ping-ponging responsibility for how King was treated. Beyond that, King's lawyers are challenging the concept of qualified immunity that law enforcement agencies use to shield themselves from lawsuits. The Institute for Justice has put up a page explaining the case and the background behind the lawsuit. And they note about the jurisdictional games being played in the case. Applying these protective standards to the officers, the trial court held that James had guessed the wrong claims to bring against the officers, but even if he had not, the officers were entitled to qualified immunity because they could not have known that stopping, searching, beating, and arresting an innocent person violated the Constitution. How would they know that? Now, the Sixth U.S. Court of Appeals reversed the trial court in every way but one, holding that the officers were not entitled to qualified immunity, but that they had acted under federal authority, not state authority. So now the government is asking the U.S. Supreme Court to step in and provide additional protection for the officers, immunizing them from liability under a new interpretation of the Federal Tort Claims Act. And at the same time, James has asked the U.S. Supreme Court to reject the government's new arguments for immunity and end the shell game that allows officers to violate the Constitution without consequence. So, just in case this isn't crystal clear, two non-uniformed people approached the man on the street, started asking him questions. When he tried to move on with his life, they grabbed him and put him up against an SUV and grabbed his wallet. Believing he was being robbed, rightfully, he tried to make a break for it. They then ran after him, tackled him, and beat him unconscious in front of witnesses who filmed it and called the police. Said, yeah, some guy's being beaten in broad daylight. When the police show up, the ununiformed people say, hey, we're cops, we're cops. So then the uniformed cops go around and try destroying the evidence, saying, hey, everybody, if you filmed that, delete it. And so they then said the man had resisted arrest, took him to trial. He was found not guilty by a jury, obviously. So now when he files the lawsuit, the state cop goes, you can't sue me because I'm working with the feds. And the FBI guy goes, you can't sue me. I'm working with a state cop. And they both claim immunity under the other jurisdiction. And the problem is that there's a loophole on each side, and they're trying to claim both loopholes. And over at the Washington Post, former Reason editor Radley Balko notes that the proliferation of these multi-jurisdictional task forces has led to a number of examples where jurisdictional confusion is used to avoid accountability and responsibility. And they're doing this on purpose. In Missouri, marijuana task forces avoid state-level public record requests by claiming to be federal agencies. But then they claim to be state agencies whenever anybody attempts to use the federal Freedom of Information Act to get information. So it's one entity. But if you send them a state request, they go, hey, we're federal. You send them a federal request, they go, hey, we're state. Balko also takes note of the deliberately complex and obtuse civil asset forfeiture law variances between state laws and the Department of Justice's equitable sharing program. This program allows many state and municipal law enforcement agencies to bypass state laws that put restrictions on how much they can seize and keep from the people they arrest by partnering with the FBI and the DOJ using the federal seizure system with its looser rules. Some states have had to pass new laws forbidding their own police from bypassing state restrictions and going to the feds, and others have allowed it to continue. So we've talked before, and I hate to keep getting back to civil asset forfeiture. Somebody actually said to me the other day, Steve, are you a civil asset forfeiture attorney? It's all you ever talk about. No, not at all. I'm a lemon law attorney. I do consumer protection. But civil asset forfeiture affects everyone, and it could affect everyone. And so since it could happen to you, you need to know about it. It could happen to me. I need to know about it. And it's the most outrageous thing in America today, I think, on the legal scene. But the point is that there are states now passing laws against civil asset forfeiture. But it only affects state actors, meaning that the feds can still operate in those states and do what the feds do because they operate under their own rules. So a lot of state forces are getting together with the feds going, hey, let's work together on this stuff, especially because the feds are allowed to share the proceeds with the state, even though the state might have a law saying they don't do that anymore. So some states, as pointed out, have actually had to pass laws saying, when we said no civil asset forfeiture, we also meant you can't team up with the feds to do the exact same thing we just outlawed. But getting back to Mr. King in Grand Rapids, imagine this. You're walking down the street, sunny afternoon. Grand Rapids is a beautiful city. Two strangers come up and start asking you questions. After a while, you get tired of it. You start moving on. They grab you, put you up against a vehicle, grab your wallet, and you, rightfully thinking you are being attacked, make a break for it. The two men chase after you, grab you, and beat you unconscious, and then they charge you with the crime. When you're found not guilty by a jury of your peers because you didn't do anything wrong, and you try to sue those two men, they both go, oh, I'm immune from prosecution because I'm a federal agent. And you say, okay, fine, I'll sue you under the federal statutes. Oh, I'm also immune from prosecution because I'm also a state agent. So I'm both, or either, or neither, depending on which loophole we're trying to do here. It's a little loophole dipsy doodle thing. So that's a crazy set of rules. And unfortunately, if this goes to the U.S. Supreme Court, I suspect they're going to go, well, the rules are the rules. They need to be changed, but we can't change them. And, of course, the Constitution is the original rule, okay? So if you look at the Constitution defines how our government's going to be laid out and the most basic of rules. And then it says, Congress can pass laws and the president can sign them into law if Congress passes them. And then the judges can interpret those laws and so on and so forth. But there are rules in the Constitution itself, such as the Fifth Amendment and the 14th Amendment. And so the idea that this gets before the Supreme Court, for instance, the Supreme Court should step up and go, it doesn't matter what your stupid rules say. It's such an obvious violation of the Constitution to allow such a set of facts to play out this way, where two bad actors can say, I'm with stupid. The other one can go, no, I'm with stupid. It's basically what they're saying. And by being with the other guy, I'm immune. No, I'm immune from being with him. It's crazy. It's crazy. So this is a story I will continue to follow. And like I said, I have to thank the people who passed it along to me, including, it shouldn't be that complicated, but I got so much paper laying around. Thank everyone who sent it to me, including John, and I believe Tim also passed it along. So there you go. I will follow this story as it unfolds. Questions or comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. You cannot be lonely if you like the person you're alone with.